8 and 9. Due to waterlogging, my senior, Mr. P.D. Nair, couldn't come to the court today. We have taken consent from the other side.
So both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after
After 26 July.
ensuing summer vacation.
Highly obliged.
May please your lordship. Lordship, I beg to mention for listing IA lordship for
Listing given to the courtmaster.
obliged.
Or prayer for listing, give it to the courtmaster.
Your lordship, I would like to mention an item for listing your lordship. The compassionate appointment.
May I please your lordship? I have to mention for listing of the.
You have heard us. You have heard us.
Lordship, I beg to mention item 11 of today's daily discussion. Lordship, in this matter, I need to obtain some instructions. So it may be posted immediately on reopening, Lordship.
It goes after vacation, make a mention after that.
Lordship.
Both sides are represented. You are taking consent?
Yes, Lord.
Okay.
Yes.
Both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after ensuing vacation. Summer vacation.
Applies, Lordship.
Supplementary item 30, 31, 32 to be spoken to.
I think, my lord, in item number, WPC 8334, I think initially lordship dictated the order, and following my submission, lordship said matter will come after 4 weeks. That somehow has.
Okay, yes, it's typed as
Yes.
close.
And in the other two cases, virtually the same order, I think they also considered that it should be remanded back to the ICC.
I see.
That was the.
And the middle one,
No,
where
in
it becomes inflexible.
the second one, the orders is one matter, the order is ready.
Yes.
But since this
Confusion
was made for listing of this matter, I could not deliver it.
My lord.
So, okay, that will recall. This in which item, Mr. Chaudhary? This
8334 of
Item
4 of 22.
8334 of 2022. As for the learned, both sides are represented. Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. P. Kothari, counsel for the petitioner, submits that on the last occasion, he made a prayer for adjournment of the matter, which was erroneously typed as not pressed. Stop. Third, Mrs. M. Hazarika, senior counsel, assisted by Mr.
D. Khan.
D. Khan, counsel for respondent numbers 1 to 4. As the mistake in the order is apparent, the same is recalled. The matter stands adjourned. List on. We will give a date last year.
After vacation.
Last time it was 4 weeks, Miller. So now it will be 3 weeks.
Okay, we'll check it out because these are. This week, I will.
29/7 of list.
29/7.
Appellate authority.
29/7.
This one is all right.
Deeply.
Lordship, no, the other one is okay, all right.
In one matter, the judgment is ready.
Yes.
I dictated half.
Yes.
On the last occasion, when the issue was raised, you gave us the letter.
Yes.
So that we incorporated later.
2961, it's after list on 29/7.
29/7. Yes.
Yes.
This courtmaster has the record.
And the third one also 29/7.
No, the third one judgment is ready. It was half dictated.
Yes.
Because of that, it had to be
Basically,
adjourned.
problem lies with the first.
Only the first one, problem. So that also may be listed on 29/7 because the other one is being. No, the suspension and the third one.
Two matters are being listed on 29/7.
Yes, yes.
And the third matter, I won't remember my number. Third one, dictation was half given, so I completed it. In fact, today morning, I was unwell yesterday.
That's okay.
For last 2 days, I'm not well.
There's no rush, Lord.
Huh?
There's no rush.
No, but bar has to be given an explanation.
No, there is no rush at all.
Deeply obliged.
Obliged.
Item number 1 for admission.
book list bisa. Book list kon dia.
Mr. Chaudhary, you are appealing for the FCI.
Yes, madam.
If the remarks are not communicated, now it is well settled after Devdutt. We hardly have a choice.
No, my lord, even in case of uncommunicated adverse entries also, the law is otherwise. But if your lordship kindly, my lord, before your lordship embarks upon this case, can I just make a prayer? There's a judgment of the Supreme Court in 1992 2 SCC 299. Boykundranath Das versus Chief Medical Officer. It's a very,
Okay.
authority on the subject.
I will also be relying on.
Ah. No, in fact, what I'm saying, my lord, in the para 34, the contours of the power of 226 has been laid down. Even that takes care of that uncommunicated adverse entry also. Your lordship, so kindly have a look at para 34.
No, I will be relying on it.
Ah.
I will be relying.
Then we
Definitely,
hear
this is
Mr.
my
Patil
first
then.
case. This will be my first case.
I thought that if that be so, the matter has to be remanded back to have a fresh consideration.
If otherwise lordship found that is not consistent with the principles laid down in this case. In fact, my lord, this is not the only case. 21 officers were compulsorily retired by invoking FR 56A, and many other challenges were made before other high courts of the country. They have got the judgments, my lord, where the decision has been upheld.
No, these have been remitted back to the authorities to reconsider. I have the copies.
On remand,
Delhi High Court and Punjab High Court has remitted it.
no, on remand it has been upheld.
On remand?
Yes, subsequently.
Oh, on remand it has been upheld. That's a different.
No.
We are yet to come up to that stage. My lord, may I begin?
Yes.
Order of compulsory retirement
Yes.
per se is not a order of punishment. It can be interfered with. It can be interfered with if it is in number 1, if it is in violation of the service regulation or circular issued under that regulation, or if it is an arbitrary or non-application of mine to the records of the case. Now, in the present case, an officer who came up from his entry grade of assistant general manager, then promoted to the DGM, then to the general manager, and was working for 22 years, he was suddenly compulsorily retired at page 64. I will come into in details first. I am giving a summary. At page 81 is the order copy when he filed a representation. They call it representation, that's an appellate. Now, before I take your lordships to the factual details in brief, just to familiarize myself, they have a regulation called staff regulation. There is a provision called regulation 22. In that staff regulation, the general power to compulsorily retire an officer is there. But to rationalize that power, they issued a circular, and that circular is at page 85 of the writ petition. Now, that circular, in fact, is to rationalize that power. Now, if only few of the clauses before I read, clause 8, your lordship will see, they have a 3-tier mechanism. First, there is a review committee constituted with 3 officers to be nominated by the corporation. That review committee reviews the service records of the officers. Now, that review committee, how they will perform, there is a criteria in clause 10. The clause 10, we get two criteria. Clause 10 says that if his integrity is doubtful, number one, or is ineffective. So these are the criteria. Now, with these two criteria in mind, they ultimately scrutinize the records of the officers. Now, after they scrutinize, they submit a report to their appointing authority, the chairman and the managing director. Now, how do the chairman and managing director perform? That is in clause 10. I'm sorry, clause 12. Clause 12, the approving authority has two duties. He has to consider it. Then only he can approve. That means consideration and approval, if I can take your lordship, the language used. Clause 12. The
Which page?
Page 88. Middle portion, clause 12. The recommendation of the review committee will be put up for consideration, this is one word, and approval of appointing authority. So, appointing authority has to consider, then approve. Now, in the present case, your lordship will look at page 64 of the petition. This is what came out, consequence of consideration and approval. Page 64 and excerpt 8. This is the outcome of the consideration and approval.
Yes.
This is after review. Then if I can take your lordships back to clause 13, there is a provision for representation as against disorder. As a lordship. So
Where?
I filed a representation, which is also on record. Now the representation, who will consider this representation? Your lordship will look at clause 8B. Page 87. Who will constitute who are the members of this? There are three members. I'm so sorry.
Yes.
There are three members. And there is another committee.
You are referring to B, representation committee.
Yeah, first one is, my lord, review committee. Who are the members? Representation committee.
Yes.
My lord. When I file the representation, the outcome of this representation is at page 81.
Yes.
As a lord.
Yes.
Now, whether whether it is review committee, the first committee, or a representation committee, the criteria they have to keep in mind while considering whether I am fit to be compulsory retired or not, your lordship will look at clause 10 at page 87.
Yes.
Yes. Now there are two criteria, basic criteria. First is that I must be a man of doubtful integrity, and second is I am ineffective. And how is that ineffectiveness is to be judged? Is that about my fitness and competence. These are the two
Yes.
things that have to be kept in mind. Now, if your lordship comes to page number 10, which is the part, in fact, I have quoted it from the Annexation 9, my representation. Annexation 9 is the representation. Page number 10 actually is a part of paragraph 9.
Yes.
From 2000, my first day joining, up to 2022, these are my APAR, Annual Performance and Appraisal Report. And why I am showing my lord, this is not denied. This is not in dispute now. What is also not in dispute, that from AGM, I got promoted in 2010 as DGM, 2010 or 11, no? I'll stand corrected. Now, subsequently, on your lordship will kindly note, on 31/10/2009, as your lordship, 2009, I was promoted to the post of GM, General Manager, at page 71.
2019.
2009, oh, I'm sorry, 2019. My lord, I stand corrected. Thank you. 31/10/2019, I was promoted from the post of DGM to GM, General Manager.
Yes.
So, and my order of compulsory retirement, your lordship will kindly note, 12/6/2023.
Yes.
Now, may I have the indulgence to take your lordship to clause 10 Roman 4? The governing circular. At page number 88, my lord.
Yes.
No corporation employees should ordinarily be retired on the ground of ineffectiveness if he is serviced during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found satisfactory. There is no such stipulation, however, where corporation employee is to be retired on grounds of doubtful integrity. In case of those corporation employees who have been promoted during the last 5 years, the previous entries in the APAs may be taken into account if he was promoted on the basis of seniority cum fitness and not on the basis of merit. Now, what I want to say, my lord, here, now, within that 5 years period, the 5 years period was to expire in around 24. Now, so therefore, it is not that they cannot retire, compulsory retire me. They can. If there is some visible meticulousness they have to adopt. Now, the question is, my lord, there are 2 grounds remain regarding my integrity. That, my lord, the APS also that whether I am a man, they are giving it good and excellent. Now, another aspect your lordship will kindly see that regarding my competence, your lordship will kindly see paragraph 30 of the affidavit in opposition. There is no other paragraphs. They are neither denying the APAs recorded in. They have shown that I am ineffective because there is a statement in paragraph 30. Is my recollection correct? Lordship will give me one. Huh? Hmm? Hmm? 112. Probably. Page number 112, my lord. Has your lordship? And who has shown this affidavit, your lordship will kindly come to the first page. He is an assistant general manager. My lord, all points have to be taken before your lordship. Who is 38 years old. Now your lordship will come to the affidavit page. Paragraph 30 is his personal knowledge saying that I am not competent. Lordship will kindly bear with me to the affidavit portion. How they are swearing this paragraph. He is saying, page 122.
Yes.
This particular paragraph that I am incompetent, has a lordship,
Yes, yes.
is shown by an AGM to his personal knowledge, has a lordship.
Yes.
And a man of 38 years, that means he knows what I did in 2000 when he was 17 years old. His personal knowledge is that I'm unfit, ineffective, because my integrity may not be doubtful, but I am ineffective. That is shown from the personal knowledge of the AGM. That your lordship kindly take. Now, on 29, a boy of 17 years old when I joined my service. And he says about this.
I'll tell you something which happened in this court. When I was a student in Commerce College, I used to do petty works, earn some money in the meanwhile. Few of the friends who were small-time, part-time contractors, be attached to them, some tidbits, and then you get paid. For this FCI and the this what you call New Guwahati Depot.
Right.
A litigation came to the court. And the only question I asked was that he was a labor. The only question I asked was that what is his income? And the senior counsel who was holding the brief was angry that how could the court ask a personal question? I'm saying that no, you are alleging that the extra money, you were there, I think. Some extra, no, you're not there, okay. Some extra, what happened was there was a scam in this FCI, there was a scam. The scam was that say X quantity of items were there. And those were to be refilled from a torn sack to a correct sack, a good sack. And in the meanwhile, the original quantity, say, supposing it is 1 lakh kgs, became 10 lakh kgs. And extra money was taken by the laborers. So I just asked what was the income. And the senior counsel was angry. This is a personal question I should not have asked. So you see, when we have personal knowledge about things which are happening, at times we tend to have prejudice because of the fact that we know how they extort.
Yes, yes. That is, while I also did some cases for the FCI, ultimately I detected a peculiar thing. There was supposed to be a depot, that is called depot, in Arunachal. There are trucks were going, it was down, offloaded, everything is record was correct, but somehow the people were not getting it. And on the request of the Controller Auditor General, who referred the matter to government, and matter came, I checked up the check gate registers. Numbers were there, car numbers. When I went deep into the matter, those are motorcycle numbers registered in Tinsukia. It happens.
No, I'm just saying that this man who was 17 years old, as I knew it during my college time. Maybe it's quite possible that he also knows it. Personal knowledge.
Might be,
Might be.
might on the lighter side, answer might be.
Yes.
And personal knowledge comes from different sources.
Huh?
Well, this is one side of the aspect of that. Your Lordship, there is another important day. On 9/7/2021, there was a review committee which took up my case after I became GM. After I became GM in 2019, 2020-21, the review committee, as a regular process, they took up my case. On 9/7/2021, they found me fit to continue as GM. That was 2 years back from the impugned order. And why on 9/7/2021 they took my case? Because the sorry. On 9/7/2021, they took up my case because as per their governing circular, anyone who attains the age of 50 years, their records have to be looked into. And that time I was GM and they cleared me saying that I am fit enough to continue. Fit means all these two criteria do not, at least do not cover me. Now, after 2 years, they found me unfit. In the affidavit in opposition I have sent, for finding me unfit in 2 years, they have said that I was censured in 2011. They promoted me also thereafter. There was a case which was ultimately dropped. All those things have been referred to and relied upon as a reason for they now sending me on compulsory retirement. Now here, this kind of situation is also covered by clause 7 of the circular. Clause 7 of the circular, your lordship will get at page 87. Has your lordship. Well, this kind of situation, it's not that they cannot compulsory retire me. They can.
Yes.
May I take your lordship to page 87, clause 7. I'm not saying there is a bar for them to send me on compulsory retirement.
Yes.
There is also no bar,
You're reading where?
clause 7 at page 87 at the top.
Yes. Yes.
There is also no bar on the corporation to review any such case again where it was, that means I was found fit, again after 2 years I was found unfit. It was decided earlier to retain the officer, but the appointing authority is of the opinion that it is expedient to undertake the review again on account of changed circumstances in public interest. In such cases, the appropriate authority is expected to demonstrate visible meticulousness. Has your lordship? Visible meticulousness as such corporation employees have been found effective on the earlier occasion. So only 1.5 years back, you found me fit. So I am not saying I cannot be sent on compulsory retirement. But if the appointing authority wants to do that, the records have to show that they were visibly meticulous. And here, that is, in my humble submission, my lord, that is missing. Because in the affidavit in opposition, they are saying 2011. After that, I became DGM also. And that all those things were already considered. And I was promoted. Again, 2021, after my attaining 50 years of age.
No, but if you are relying on the record, we have never asked for the calling of the record.
No, my lord, that specific order was there. There are 6 orders, procedural orders. In the last order, your lordship will say the records were directed to me because this is the last order.
Oh, acha. Yes. Okay. Yes.
Now, in my humble submission,
Records are available?
Yes.
Okay.
Only thing is, my lord, we got the record this morning. We'll just go through it, then hand over.
now, in my humble submission,
Yes.
That visible meticulousness is missing because of two things. Number one, they have again from the affidavit in opposition, I do not know what the records say about it. They again referred to the 2011, 2014, 2017 and has not looked into that my promotion and has not looked into that I was asked to continue in 2021. If the record says some reasons, I have nothing to submit on that.
But what happened to the proceedings drawn up, disciplinary proceedings, Annexure 6?
That was dropped.
It was dropped.
Now, Your Lordship, I have another submission. Your Lordship, with reference to clause 12. Clause 12, I am taking Your Lordship page number 88. There are two words regarding how the appointing authority has to function in the matter of. First, when the review committee gives his report, he has to apply his mind, consider, then approve. Now, from page number 64 and 681, one cannot make out whether he has considered. He is just approving it. So, at least from the impugned orders, he is not available. Then I argue against myself for the time being. From page number 64 and 81, one word has been used. It is in public interest. It is the cause. It is not the reasons. Cause is this, but you have to consider and give the reasons. Merely quoting the cause, and because I'll come to the judgments also, my lord, in a compulsory retirement case. Merely quoting the cause, it is in public interest. You are ineffective. First, your duty is to consider. Then, you're merely stating the cause per se will not make the impugned orders valid. Now, from page number 10 to 13 of the writ petition, they could not have formed an opinion that my integrity is doubtful. These are not denied, my lord. This paragraph itself is not denied in the affidavit. Rather, except I stand corrected. In paragraph 30, he says, I am doubtful and ineffective from his personal knowledge. These records are not disputed, but whether these records, undisputed records, for a reasonable person, can make out a case of me being dishonest, ineffective, my humble submission, it will be not like that. Now, your lordship will kindly see I am coming to Boykunthonath Das case. That case my senior colleague was making. My lord, I have made it. Boykunthonath Das to us. Boykunthonath. My lord, I have also made a compilation of the judgments which I will be referring. My lord, just bear with me for it. এখন মনে করবো please, মনে করবো। Judgmental copy. Oh, it was. Sorry. In the Boykuntanath case, my lord, your lordship, I take your lordship to paragraph 34. That is paragraph. Paragraph 34 লিখা আছে। At page,
Para?
my lord,
Para?
70,
Para?
paragraph 34. An order of compulsory retirement is
Just
not,
on, just on.
I'm sorry. Page number 70, running page 70. Two, three,
Yes.
and
Paragraph?
4, my lord,
Paragraph
paragraph 34.
34.
At running page 17, my lord.
Yes.
My lord will see, look at paragraph 34. 2. There are many guide. All the principles were given, my lord.
Yes.
34 Roman 2, my lord, has a lot. The order has to be passed by the government on forming the opinion that it is in public interest to retire a government servant compulsorily. The order is passed on subjective satisfaction of the government. Number 3, principles of natural justice have no place in the context of an order of compulsory retirement. This doesn't mean that a judicial scrutiny is excluded altogether. While the High Court or the court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed mala fide, A, B, it is based on no evidence, C, that it is arbitrary, in the sense that no reasonable person would form the requisite opinion on the given material. In short, if it is to be found to be a perverse order. Therefore, my lord, your lordship will kindly bear with me to say in clause 12, the requirement of, most probably because of this clause, the requirement of independently considering the review committee's report by the appointing authority was provided. There is 2 words. Before approval, he has to consider. Your lordship will, may I take
Yes.
your lordship to clause 12?
Yes, you've seen that.
Yes. Now, my lord, will come to Roman 4. The government or the review committee, as the case may be, shall have to consider the entire case record of service before taking a decision in the matter. Of course, your lordship will kindly see, of course, attaching more importance to record of and performance during the later years. Here, the affidavit in opposition speaks of 2011 incident where I was given censure. After GM, they considered me and found to be fit. there must be some, if there is anything so strong that I'm not saying they cannot, they can, but it must be very visibly meticulous. Now, after that, my lord, I take your lordship page number 19. Yeah, that's South Indian. That's it. Copy it. I don't know, copy. May I take a lordship the other decision? Page running page 19. Central Industrial Security Force. Om Prakash versus Om Prakash.
Yes.
I take your lordship to paragraph 15 of this judgment at relevant page at 27.
Okay, this is also reported in SCC.
It
It is
is reported, but I could not find out the
2022 5 SCC page 100.
in that case paragraph may not tell you, my lord.
No, it will not tally.
It will not tell you.
It will not.
Here, the apex court says the recent reports would bear their own weight. Appears. The appears which they have not denied in their affidavit, rather accepted, except that paragraph 30. They are now in the affidavit of opposition saying this is 2011, 2013. Now, I take your lordship to 2000. 2001, 3 SCC,
In this, you are relying only on paragraph 15,
my lord.
earlier judgment, only paragraph 15.
Only paragraph
CI, sir.
34,
Huh?
that Vaikunthana.
CI, sir.
Paragraph 15, only paragraph 15. For the purpose that my recent reports have their own bearing. The weightage have to be given, the last sentence. Your lordship.
Yes.
Your lordship. The next judgment, 2001 3 SCC, page 314, State of Gujarat versus Umed Bhai. It starts from page 28, madam.
Yes.
Your lordship will come to paragraph 11, which is at page 34.
Yes.
Roman 6 and 7, there are different directions, my lord.
Yes.
That there is Roman 6 and 7. The order of compulsory retirement shall not be passed as a shortcut to avoid departmental enquiry when such course is more desirable. If the officer was given a promotion despite adverse entries made in confidential record, then that is a fact in favor of the officer. As a lordship. So I'm not saying that I was not censured in 2011-13, but at the same time, there was a promotion subsequently as DGM and general manager. Now, I take your lordship to page number 35. Rajasthan State Road Transport Corporation versus Babulal Jungi.
CC 5755.
Yes.
Paragraph 20, your lordship will look at page number 49, running page. It has referred to Vaikuntanath. Badrinath. Vaikuntanath.
Yes.
In paragraph 20 of this judgment at page 49. May I read, my lord? Paragraph 20, my lord.
Yes.
May I read? If one were to go by the dicta in Vaikuntanath case, obvious conclusion would be that even if there are adverse remarks in the service career of an employee, they would lose their effect when the employee is given promotion to the higher post and would not be taken into account when the case of that employee for compulsory retirement is taken up for consideration. Except only these adverse entries are in the confidential reports of the employee which touch upon his integrity. That means previous will not be taken. Later on period also it will be taken only which touches the integrity. This does Vaikuntanath case interprets principle 4 in paragraph 32 of Vaikuntanath thus to mean such adverse remarks for the period prior to promotion, unless they are related to dishonesty, would be substantially weakened after the promotion. Now, next judgment, my lord, lordship. Captain Pramod Kumar Bajaj versus Union of India.
There's a typographical error.
My lord.
There's a typographical error in page 20. Weekend, it should be WEAK.
Thanks. I'm sorry.
That's okay.
Now, next case is my lord Captain Pramod Kumar Bajaj versus Union of India. That starts at page 61. May I read from paragraph 8, my lord, at page 63? 8, 9, 10.
Just Yes.
I'm reading out from paragraph 8, my lord, page 63. Here it is a case, my lord. They not only considered my case, after considering in 21 my case, they also took my case along with many other officers. Unlike the other 21, and this time they did it. Now in paragraph 8, may I read?
Does it? Okay.
May I read, ma'am?
Yes.
It may be noted here that the mechanism in place within the department for arriving at a conclusion as to who amongst the Group A officers in the CBDT deserve to be prematurely retired starts with an assessment to be conducted by the internal committee that identifies and recommends the names of the officers and places it before the review committee. The next, my lord, the first committee here also in FCI, there is one more committee which I forgot, called internal committee. They prepare the records, place it before the review committee. It before the review committee. The next stage is before the review committee that I include chairman, CBDT, and the revenue secretary as members, if satisfied by the records and comments forwarded by the internal committee that the premature retirement of a group officer is desirable in public interest, the review committee makes recommendation to the appointing authority in this regard. The appointing authority is then required to examine the recommendation of the review committee and if satisfied, pass an order of premature retirement of the concerned officer. Same as my lord FCI. Now your lordship will kindly see paragraph 1911, the facts of the case. Now I am taking your lordship to paragraph 15. At page 66. What is the scope of judicial review? Paragraph 15, my lord, is already I have submitted. It's very limited. If it is in violation, that's what paragraph 15 deals with. Now, paragraph 18. The apex code refers to Swami Sharan Saxena's case. Now, paragraph 19. In Baldev Raj Chadda, the apex court, your lordship will see, has quoted the paragraph 25 of that judgment. But under the guise of public interest, if unlimited discretion is the whole purpose of fundamental rule so and so is to weed out the worthless, without the punitive extremes covered by 311 of the Constitution. But under the guise of public interest, if premature return, if unlimited discretion is regarded acceptable for making an order of premature retirement, it will be surest menace to public interest and must fail for unreasonableness, arbitrariness, and dismissal. Into paragraph 20. Your lordship also will look at paragraph 20.
You can go and call it. It will take some time.
It is paragraph 20 deals with that if a compulsory retirement order says public interest, does the matter ends there? Court said it is not like that because merely saying that it is in public interest. So paragraph 20 deals with that. That lifting the veil. Now, paragraph 24. Your lordship will look at page 71. It's a short paragraph, my lord, so that I can read it.
Yes.
In so and so case has once again. He may be allowed to read out this.
In Nan Kumar Verma versus State of Jharkhand, this court has once again highlighted the permissibility of ascertaining the
Just
existence
a
of.
moment. Just one. No. I'll continue. Let him continue. I just remembered the episode. I'll tell you. I forgot the name of the learned counsel. He came from Delhi. It was a DK Jain. You know him.
I know.
He. No, Mr. Chaudhary, this is something very interesting. In court number 7 in the old building, he was arguing a matter. And after that, to read the SCC, he asked his assisting counsel to read it. And the court was annoyed. This can't happen. So then he said that I am prepared. So he took out a typed copy and started reading like this. And then he addressed the court. So he said, what you are doing? He said, Lordship, I am blind. And therefore, I am reading in Braille. So then the court said, no, please ask your junior. No, once your Lordship has expressed your desire, I am prepared to read it. I have typed out everything in Braille and then before I am addressing the court. I am told that he is now a senior counsel.
Yes, he is a senior.
Delhi High Court. And he came to our courtroom without any assistance. He came to the spot, sat down without any assistance. And
Was it an election matter, Mila?
I don't remember. That's about
I
10,
think he
15
did
years.
lot of the-
15 years back.
Election cases.
I don't
He
remember.
does election cases.
15, 20 years back.
In fact, he used to wear Prince coat, na?
But that was his performance. I still remember. I took his name and then I still remember it to this day.
I was told by somebody that he's an expert in election law.
Maybe, I don't know. I
He
won't
is,
remember that.
He is.
Congress party.
Both is good.
Yeah.
In fact, we are also, my lord, we also had the rather privilege to have one senior counsel, Mr. DK Bhattacharya. He remembers everything, but sometimes he needs a junior assistants to read
No,
out.
that's okay.
He had
But-
some.
No, I understand. But this is a performance I would.
And he used to drive also.
Yeah.
It's a-
No, you let me continue. Mr. Chaudhary
No,
can read.
I can,
Yeah.
because I just wanted to. Paragraph 24 at page 71. In so and so case, the court has once again highlighted the permissibility of ascertaining the existence of valid material by a court for the authorities to pass an order compulsory retirement and observed thus, as your lordship. It has been given in both. It is also well settled that the formation of opinion for compulsory retirement is based on the subjective satisfaction of the authority concerned, but such satisfaction must be based on valid material. It is permissible for a court to ascertain whether a valid material exists or otherwise on which subjective satisfaction of the administrative authority is based. My lord, here I pause here for a minute. Here the picture that comes in front of me is that here we find that this is a man where the FCI now, after the first review committee cleared me, wants to refer it to the 2011 and 2013, those cases. Now again he has done it. Now it is also that comes in front of me. The apex court has said the later years APA and the annual performance, those should be taken into account. Now they are referring it back. It also comes in front of me that most probably after realizing this, they make an affidavit at the last page again that he is ineffective. He is so and so, and that took from personal knowledge of someone. For that purpose, this paragraph 24 I wanted to apply. Now, paragraph 30, my lord will see. Here also the apex court has quoted the entire in paragraph 30. Paragraph 30.
Yes.
Last sentence, because I will not trouble your lordship with the entire paragraph. Nothing has been placed on record to show a sudden decline in the work on the work conduct of the appellant so as to have compulsory retired him. There is nothing, no whisper at all. That visibly meticulous, this is the word used in their circular. That when they say that I am visibly meticulous, because clause so and so says, you have to come with materials that this is what ultimately the sudden fall. And to the best of my information and instruction, there is nothing. Rather, the APA says it differently. So that purpose I showed it. Now, your lordship will kindly come to paragraph 33. At page 79. Undeterred by the aforesaid judicial orders, the respondents continue to withhold the vigilance clearance of the appellant, this time claiming that there were some adverse findings against him in an inspection report dated 2018, stated to have been prepared on the basis of an inspection of the office in 2017. Regarding what happens about the back years. I'm so sorry. This paragraph 33. Your lordship will come to paragraph 37. Regarding that one cannot resort to compulsory retirement deviating from the departmental proceedings. I will, your lordship is a settled law, I remember. But then 39. My lord, it deals with that how it lifting the veil theory, my lord, how it serves the public interest. They have said it is in public interest. The last sentence. I came across another judgment of lifting the veil theory applies. How it serves their purpose of public interest. Now, next decision, my lord, only one paragraph remains. Page number 84. No citation. I'm sorry, man. I'm sorry. My lord, next judgment, 1993 SCC, page 504. My lord will look at page number 84. Only one paragraph, my lord, paragraph 32. At page 96, my lord. May I read, my lord?
Yes.
On a consideration of the above decisions, the legal position that
Page
now
number?
emerges is that
Page number?
page number 96, paragraph 32.
Yes.
On a
Placitum? Placitum?
paragraph, you wanna see it? 32. D and E.
No, page 84 is Kartar Singh.
Page 96, my lord.
96 is that case of Ram Iqbal Sharma.
Ram Iqbal Shah.
It does not have page, paragraph 34.
32, I'm 32 in the middle of page number 96 running.
No, this is part of paragraph 5. Just check up. Just check up.
Number 6. 26, 26.
623.
Page 96.
Page 96.
Into an order. A
Four,
representation
96
taken.
full lord. Huh? The one. I apologize. It's my mistake.
No, it's okay.
Can I get photo?
Represent.
Just give me the citation.
Yes.
1993 SCC, volume 3 SCC, page 504,
1990,
volume 3 SCC,
page
504. Relevant page 516. It can get 84. Photo की खुली खुली सब हाँ it can get खुली सिलाई की इतिहास
no, it's okay, it doesn't matter.
photo copy
General platform function to the
Ram Iqbal Sharma. Paragraph 32.
paragraph 32. My lord, after the my lord, can I
How does it start, Mr. Pathak? How does it start?
paragraph starts on a consideration of the above decision.
Okay, yes.
The legal position that now emerges is that even though the order of compulsory retirement is couched in innocuous language without making any imputations against the government servant who is directed to be compulsorily retired from the service, the court, if challenged, in appropriate cases can lift the veil to find out whether the order is based on any misconduct of the government servant concerned or order has been made bona fide and not with oblique and extraneous purposes. Mere form of the order in such cases cannot deter the court from delving into the basis of the order if the order is in question is challenged by the concerned government servant. Why I wanted to submit, my lord, from this judgment.
Yes.
One thing is crystal clear.
Yes.
Even though order has been passed as public interest,
Yes.
and since they have not denied the entries made in the APA and AR performance reports, what other factors that might have played? In the affidavit in opposition, it reflects that their emphasis on my past censure and departmental proceedings. My lord.
Yes.
My lord, can I be given the liberty to correct the page number? One
Yes,
more
certainly.
decision I have.
Definitely. Do it. It's not in a hurry.
Can I get কাটিব পাৰিব? মই এইটো কৰি লওঁ। হ'ব। এখন লওক মই ঘূৰাই দিব। ফটো দিব ঘূৰাই লওঁ। এইটো মাছ মাৰি লগাম। Another judgment, my lord. 1980. কিবা মিলে নে নাই আছে?
Yes.
1980, volume 4 SCC, page 323, 321. In that compilation, my lord, it is at page 104.
Yes.
Only 2 paragraphs are it. Compilation, my lord,
Yes.
104. Your lordship will come to paragraph 8 and 9 only.
Yes.
My lord, paragraph 8 and 9 also only deals with that public interest. Is that sufficient to quote and finish of the matter? They have to, with positive assertion of facts, they have to show their visible meticulousness in
Which paragraph?
paragraph 8 and 9. Madam. The long paragraph.
Okay.
I'm giving the summary only. And now last judgment, my lord. 2009, 15 SCC, page 221.
Yes.
My lord will bear with me. Paragraph 39, 40 and 50. My lord, what for I exactly wanted to rely on this judgment?
39, 40 and
39, 49, 50 and 51. The purpose of relying on is like this, my lord.
just come again. 39,
39, 49 and 50.
50.
50. The purpose is to, my lord, that merely saying that what is cause and the reasons. Your lordship will see page 81 and page 64 of the writ petition.
Yes.
Why? And the purpose of showing this, my lord, page 64 and 81 of the writ petition. Except saying that it is in public interest, that is the cause. On that cause, definitely I can be done. They do not say anything about the reasons that you have done it, that this is the reason to achieve the public interest goal. Absolutely silent. So for that purpose, I have shown. My lord, I have prepared a brief synopsis of my facts. Photocopy to assemble. May I have the indulgence to correct that page number?
Definitely. No issue with that.
These are the facts.
Hmm.
Summary of the facts. Correct. Yep, right there. My lord, he was.
These are,
He was troubling me all
Six-
throughout.
these are 6 judgments on issue of compulsory retirement authored by me. All these were dismissed. We
Need to be.
uh,
Or
yes,
petitions
challenge
were
to
dismissed.
dismiss 6 of them. Just see one of this and then you'll have to also overcome my prejudice against this.
My lord. In my reply argument, definitely I will
Definitely.
overcome.
Just handing you over.
Take it.
Because once there is a. journey I
I'm
have
so
taken
sorry
on you-
that I did not come up. Did not
No,
go.
it's okay. It may not be appropriate in your case. On facts, it may
But
be
at
different.
least
I don't know.
the senior advocate is supposed to know.
No. It's
That
not
I am
that.
like. What I saw,
Those were valid at one point of time, but now with the hundreds, thousands of judgments, lakhs of cases reported, I don't think it's just possible.
Law is a concept developing only.
So, yes.
May I reply in my
Definitely.
concluding?
Yes.
Only one thing I want to say.
Go.
After
That's
many years,
personal attack. It appears from his tone that it is
no,
personal attack.
I don't have the courage to personally attack him.
Okay.
Now, only one thing I wanted to say. After many years, we have appeared on the other side each other. He was only troubling me that he is now busy and he wants to go out. I said, no, you cannot. So that made me to conclude it without reading the whole page.
Thank you so much. Made pleasure, Lordships.
No, that is also expected.
He said cut short, otherwise, and I'm scared of him, my lord. So he said otherwise. After that, he doesn't tell me anything. What is otherwise?
No. He is-
Then Learned Friend will get a right of reply so he can cover up. My Lord, the law of compulsory retirement emanating from FR 56J, as we understand this, my Lord, these are not punitive measures. These are exercise based on subjective satisfaction. However, the materials based on which the subjective satisfaction is derived, this must be objective. Now, so many facets have been evolved. So many facets have been evolved by judicial decision. For example, if in the last 5 years, an incumbent has earned a promotion, even if there are some entries which are not favorable, those gets diluted, but those doesn't get obliterated. End of the day, the preponderance of judicial view, in my humble submission, subject to what your lordships may say, is one has to look at the overall profile of the officer. If on the basis of overall profile of the officer, a subjective satisfaction is derived that this man is not contributing to the institution, not merely integrity, my lord. If somebody is inefficient, if somebody is not willing to take responsibility for the organization, then he is declared as deadwood. And the consequence is compulsory return. In my humble submission, my lord, wrongdoing, integrity alone are not considerations. Considerations are if somebody is inefficient, if somebody is not contributing to the cause of the organization he is working for, then also he could be picked up for this treatment. So therefore, my lord, overemphasis on integrity and always is not helpful. That's why, my lord, in Kandaswamy's case, Supreme Court said, constitutional rights, statutory rights, very well. These are conferred on the citizens and the employees. But what about their corresponding duty to contribute towards the system? What will happen if he is inefficient? Therefore, my lord, yes, the right balance has to be struck between the rights, constitutional rights and statutory rights, and the expectation of an employer from the employee. It is in that pursuit, my lord, that this law has evolved. Now, the fundamental point which I find from the writ petition is Now, in my humble submission, the fundamental point which has been asked by my learned friend is that he was compulsorily retired on 12/6/23. And 5 years down the line, that is on 14/8/20, sorry, 31/10/19, he was promoted as general manager. Basically, that is the point he's trying to emphasize. And secondly, my learned friend was arguing that since his APR or ACR gradings in the later years are good, comparatively good, then the period when he was given punishment and all. So therefore, that is also a factor which should be taken note of. I do not discount that, my lord. Yes, if in the later years his ACR performance have improved, that's definitely a consideration which has to be looked into. But that is not always decisive. What is decisive is the overall career profile. If the overall, if on a review of the overall career profile, the employer comes to the conclusion that here is a man who has become deadwood, then that is, as it is said, it would be a subjective satisfaction. And Lordship Supreme Court has repeatedly said the scope of judicial review is very, very, very limited. It is only in case of absurdity, only in case of mala fide exercise of power, only in case of irrationality. Supposing a black is construed to be white, yes, then it's a case where a judicial review may be available. But if a black is said to be dark gray, then it may not be, in my humble submission below. So in this view of the matter, my learned friend referred to that notification at page number 88 regarding the scope of review, where my learned friend referred to 10, 1, 2, 3, and 4. At page 87 of the writ petition.
Yes.
Kindly see, my lord, broad criteria to be followed by the review committee while making the recommendation are as follows. Corporation employees whose integrity is doubtful shall be retired. Corporation employees found to be ineffective shall be retired. That's why I said, my lord, if you're not contributing to the system, then also authority has a right. The basic consideration of identifying such corporation employee should be their fitness and competence to continue in the post held. Then please come to 4. I think more emphasis was laid on 4. No corporation employee should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found to be satisfactory. So what this particular 10(4) mandates is, ordinarily the ground of ineffectiveness should not be pressed into service in a situation where in the last preceding 5 years, the incumbent had earned a promotion or his performance in the promoted post is found to be sound, satisfactory. Now, this is the only one consideration. There is no such stipulation, however, where corporation employees to retire on the grounds of doubtful integrity. And this is neither here nor now. This is the last part is very important. In case of those corporation employees who have been promoted during the last 5 years, the previous entries in the APR may be taken into account if he was promoted on the basis of seniority cum fitness, not on the basis of merit. So, my lord, if the promotion is by application of criteria of seniority cum merit, not merit cum seniority, then this APRs could be considered. Now, here in our case, my lord, he was promoted based on his seniority. It's not a merit, it's not a selection post as is normally understood in service jurisprudence. By virtue of seniority and by virtue of the fact that he was not otherwise unfit, he was promoted. Therefore, the argument that because he earned a promotion of during the last 5 years, therefore ground of ineffectiveness cannot be invoked is not correct. Had it been a case where his promotion would have been based on merit cum seniority, in other words, the promotion would have been based on merit, then the ground of ineffectiveness could not have been taken resort to. So, and kindly come to Roman 5, my lord. The entire service record of a corp. Now, based on the, my lord, principles evolved in the decisions of the Honorable Supreme Court, these circulars have been issued. These are all consistent with the principles laid down by the Supreme Court with regard to review of the profiles of officers who are sought to be compulsorily retired. Now, 5 reads as, entire service record of a corporation employee should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to consideration of APR dossiers. The personnel file of the corporation employee may contain valuable materials. Similarly, his work and performance could also be assessed by looking into files dealt with by him or in any papers or reports prepared and submitted by him. It would be useful if concerned internal committee puts together all the data available about corporation employee and prepares a comprehensive brief for consideration by review committee. Even uncommunicated remarks in APR may be taken into consideration. In fact, my lord, uncommunicated entries, in fact, Supreme Court has also said that. So therefore, my lord, what transpires in my humble submission is, now different aspects can be gone into. So those are in the realm of materials. But the satisfaction of the employer would be, my lord, subjective. That's the gray area, my lord. So subjective satisfaction means subjective. But as Supreme Court has said, that subjective satisfaction is subject to judicial. Their lordships can lift the veil, find out whether it is a punitive in nature or not, or it was a bona fide exercise undertaken. In that bona fide exercise of power, even if there are some aberrations, some inappropriateness, some error, my lord, that will not affect the merits of the decision.
I'll just take a short
Well,
break and come back.
fine. Passing of this order is a punitive. And in fact, he has taken a ground also, ground F in the writ petition. But unfortunately, there is no factual background, my lord, laid down in the petition to build up that ground. Therefore, in isolation, that ground will not work. You must lay the foundation how it is punitive. It can be based on inferences. If you are saying it's a malice in fact, then it's a very serious allegation. You will not only have to implead the persons as parties, you will have to lay a minimum foundational facts, jurisdictional facts, which in my humble submission are absent in this present writ petition. My lord, to buttress the point which has been raised, I will refer to my affidavit in opposition at page 103, para 23, then para 27 at 106, and para 35 at page 116.
Yes.
Now, my learned friend made a statement based on that
Which are the
clause
paragraphs?
10.4, my lord.
Which are the paragraphs?
Para 23, 27, and 35.
Yes.
Now, please come to page 103, my lords. Somewhere in the middle, clause 10 of the FCI circular has a lordships got it.
Yes.
103.
Yes.
Clause 10 of the FCI circular dated 9/7/21, cited by the petitioner, contains the broad criteria to be followed by the review committee. Subclause 1 to thereof are extracted here and there. Corporation employees whose integrity is doubtful shall be retired. Corporation employee found to be ineffective shall also be retired. The basic consideration in identifying such corporation employee should be their fitness, competence to continue in the post held. The petitioner was transferred out of the regional office Karnataka to regional office Tamil Nadu for his poor performance and lack of integrity in the year 2011. His integrity was not recorded by his controlling officer for the year 2015, which cast serious doubt on his fitness to be considered for continuing in service. Further, the petitioner's integrity is also not clearly certified as beyond doubt by his 6 controlling officers. Rather, it was stated as nothing adverse came to the notice, nothing adverse reported. The committee also took inputs from the petitioner's personnel file, APAR dossiers, field offices on the general reputation, and the same was not found to be satisfactory as far as work and integrity are concerned. Further, clause 10(4) of the circular reads as so. No corporation employee should ordinarily be retired on the ground of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5 years his service in the highest post has been found to be satisfactory. There is no such stipulation, however, where corporation employees to be retired on the grounds of doubtful integrity. In case of those corporation employees who have been promoted during last 5 years, the previous entries in the APR may be taken into account if was promoted on the basis of the seniority and fitness and not on the basis of merit. The word ordinarily used in the above clause clearly suggests that the competent authority is not completely precluded from passing orders of compulsory retirement under Regulation 22 of the staff regulation if the promotee was promoted during the last 5 years. So, my lord, the use of the expression ordinarily makes the position clear that merely because one has earned a promotion, or you can put it this way, my lord, that merely because you have earned a promotion, it is not unqualified, it is qualified. It is qualified by what? That if your promotion is based on seniority alone, not on the basis of merit. If the employer is promoted, moreover, the second part of the clause further clarifies that if the employee was promoted during the last 5 years on the basis of seniority and fitness and not on the basis of merit, the previous entries in the APR can be taken into consideration. So the moment it was seniority come fitness, then not only the subsequent years, the earlier previous years, ACRs also can be looked in. The case of the writ petitioner is clearly covered under the second part of 10(4) of the FCI circular dated 9/7/21, as the promotion of the petitioner was made on the basis of seniority cum fitness, not on the basis of merit, as per the standard policy followed in the corporation. Thus, the writ petitioner is not entitled to claim any benefit under clause 10(4) of the above circular, even if he was promoted during the last 5 years. The competent authority has rightly taken into consideration the entire service record of the writ petitioner and the relevant factors envisaged under clause 10 of the circular dated so and so. Then, my lords, will kindly come to next page 106. Now, in para 27, my lord, we have tried to give a broad picture about his entire career and why this action was resorted to. The vigilance and administrative profile of the petitioner reflects the following position. Complaint was made by the staff of Satna division regarding alleged corruption done by Sri so-and-so, consequently was transferred to Maharashtra region-wide order dated so-and-so. The officer was charge sheeted under minor penalty clause of staff regulation-wide memo dated so-and-so, while he was posted as area manager, district office Borivali for negligence towards his duties and failure to monitor depot operations efficiently and failure to keep control over the subordinate staff. Penalty of censure was imposed by order dated so-and-so. Email dated 5/5/2011 was sent by General Manager Karnataka to executive director pointing out serious irregularities committed by officer. It was observed that his performance is not up to the mark and there is serious allegation on his integrity. It was requested to post him out of Karnataka in view of sensitivities of the contracts, maize procurement in the region based on the inputs of GM Karnataka. The officer was shifted out of Karnataka region to regional office at Tamil Nadu. Further, it is observed that the officer had not submitted his APR for this period to his controlling officer. Only a part APR of the year is available in the records. Memorandum dated so-and-so was issued to the officer for charges found by CBI. CBI, while investigating the case of irregularities in Satna Mandi during the Rabi marketing session, found serious lapses, discrepancies on the part of the FCI Mandi staff of non-maintenance of records and loss of footprints, directly attributable to the officials posted in the Mandi. The petitioner was then area manager of Satna. While memorandum dated, the officer was warned to be more careful in future. The petitioner was issued a show cause notice for alleged lapses, while memorandum dated so-and-so for not lodging FIR against HTCN, MPSWC and truck driver. A warning being so-and-so was issued to the petitioner, the then area manager. Memorandum dated 14/3/12 was issued to the petitioner, the then GM, Tamil Nadu, for explaining the reasons for not attending zonal office South in spite of being available at RO Chennai for discussing clarification sought by FCI. Charge sheet was issued to the petitioner, the then DGM, while memorandum bearing dated so-and-so under minor penalty clause for irregularities in Madhya Pradesh. All the charges were dropped while later dated so-and-so. Petitioner DGM in the then area manager Borivali was charge sheeted under the major penalty clause under regulation 58 of the sub-regulation by dated so-and-so for irregularities in labor issues and abnormality in the payment of wages in Borivali. Officer imposed reduction of penalty of reduction in pay scale by 2 stages for a period of 1 year by order dated so-and-so. During the period, the penalty, he will not earn increment and reduction will be the effect of postponing future increments of his pay. On appeal of the petitioner against the above penalty order, the appellate authority modified the penalty to reduction in time scale of pay by 1 stage for a period of 1 year. The APR of the petitioner during 2004 to December so-and-so was graded as fair, and the reviewing officer also denied to accept him in promoted capacity. The remarks of the reporting officer in APR show that officer neither has capabilities nor does he take interest in completion of the assigned work in time, even after issuance of multiple memos and warning. Fair gradings was, however, upgraded as good by the reviewing authority. Similar comments are available in petitioner's APR of 2006, then 8, so and so forth, my lord. Then last Roman 14, further, committee had gone through all the APRs of the officers available in record, which reflects that right from the start of the service, he remained average performer and at many point of time even showed as a casual worker with no initiative in work. My lord, it is good. My lord, there is one typographical error in Roman 12. Roman 12. Again, the officer was great. It should be good, my lord. Sorry, there is a typographical error. Instead of fair, it should be good. So, my lord, these all are the objective materials. We'll place the record which the review committee took note of to arrive at the subjective satisfaction. Now, my lord, as the lordship knows, my lord, the scope of judicial review, I would respectfully submit, is very, very limited. It is only in a case where one can allege malafide or where there is abject arbitrariness in the decision-making process, or else lordships will give due deference to the wisdom of the employer. Then, my lord, at para 35, what we have stated is, in that exercise, at para 35, page 116, the last subpara, as stated herein above, a special review of 320 category 1 officers who have completed or were completing 50 years of age as on 36/23 were conducted, and 21 officers, including the petitioner, were prematurely retired from service under Regulation 22(2) of the Staff Regulation. This special review under regulation was undertaken on bona fide opinion and subjective satisfaction of the competent authority that it is in public interest to pass such an order. My lord, it's not only a case of, my lord, there being some doubt about the integrity. It's a question of non-performance. It's a question of negligence. It's a question of ineffectiveness. It's a question of overall interest of the organization. So all this has to be taken note of. The overall career profile do not inspire the confidence of the employer to retain a person like the petitioner. In the subject to what your lordships may say, he has become a deadwood. He is not contributing anything towards the organization. So we don't want him. We are not punishing him. All that we are saying is, leave the organization. These are your benefits. We are not holding any disciplinary inquiry against you to find out whether you have committed any, moral act involving moral turpitude.
But somewhere I read,
My lord.
somewhere I read here
Yes.
that the survival benefit was only for 3 months' salary.
No, that was the notice.
That's a notice period.
Notice period, my lord.
There's not.
Advance he'll get, my lord. A compulsory retirement, he'll get everything, but in a reduced thing.
3 months notice has to be given or 3
The-
months.
Or notice or pay in lieu thereof.
Okay,
Yes.
okay.
Now, my lord, I'll rely upon 3 decisions. All these decision has been referred by my learned friend also, but I'll try to highlight the paragraphs which your lordships, should take note of while taking a call on this case. Let's first come to, my lord, that Vaikuntha Nath Das case. This is considered to be, my lord, an authority earlier in point of time. Now please come to para 34. At page 315.
Yes.
An order of compulsory retirement is not a punishment. It implies no stigma nor suggestion of misbehavior. The order has to be passed by the government on forming the opinion that it is in public interest to retire a government servant compulsorily. The order is passed on the subjective satisfaction of the government. The principles of natural justice have no place in the context of an order of compulsory retirement. This does not mean that judicial scrutiny is excluded altogether. While the High Court or this court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed mala fide, or it is based on no evidence, or it is arbitrary, in the sense that no reasonable person would form the requisite opinion on the given material. In short, if it is found to be a perverse order. So, my lord, with greatest of the respect, I'll submit, my lord. The scope of interference is very, very, very limited. The moment, my lord, the Honorable Supreme Court says that, yes, if it can be shown it's a case of no evidence, then yes. If it is a case of some evidence, then that's the end of the matter. Then it is arbitrary. That means the Witnessbury principle has been adopted, my lord. Whether a normal prudent person properly instructed in law in such a situation would take that decision or not. If we satisfy in, persuading your lordships that here is a case where a reasonable view has been taken, then lordships will not interfere. The government or the review committee, as the case may be, shall have to consider the entire record of service before taking a decision in the matter. Of course, attaching more importance to the record of and performance during the later years. The records to be so considered would naturally include the entries in the confidential record, character role, both favorable and adverse. If the government servant is promoted to a higher post, notwithstanding the adverse remark, such remark lose their sting more so if promotion is based upon merit and not upon seniority. So if the promotion is earned on merit, then yes, the adverse entries would lose its sting, but not otherwise if it is based on, merit, seniority. An order of compulsory retirement is not liable to be quashed by a court merely on showing that while passing it, uncommunicated adverse entries were also taken into consideration. That circumstance by itself cannot be a basis for interference. Interference is permissible only on the grounds mentioned in 3 above. Kindly come to 3 again, my lord. Principles of natural justice has no place in the context of an order of compulsory retirement. This does not mean that judicial scrutiny is excluded altogether. While High Court or this court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed mala fide, that it is based on no evidence, or that it is arbitrary. So these are the 3 judicially available grounds to interfere in an order of compulsory retirement. And respectfully, I'll submit, my lord, I don't find any materials has been brought on record, or even during the course of hearing, my lord, that any materials of the nature as projected in 3 is present in the case. Next judgment is, my lord, 2013 10 SCC 551. My learned friend referred to para 19, my lord. I'll refer to para 24 and 27. Now let us read para 19 also.
2013.
Yes, my lord. 2013 10 SCC 551.
What is the name?
Rajasthan Road
Oh,
Transport
it's-
Corporation versus Babulal Jangir.
Huh.
My lords will kindly come to page para 19 at page 561.
Yes.
If one were to go by the dicta in Badrinath, the obvious conclusion would be that even if there are adverse remarks in the service career of an employee, they would lose their effect when the employee is given promotion to the higher post and would not be taken into account when the case of that employee for compulsory retirement is taken up for consideration, except only those adverse entries in the confidential report of that employee which touch upon his integrity. Thus, Badrinath case interprets principle 4 in para 34 of Badrinath to mean such adverse remarks for the period prior to promotion, unless they are related to dishonestly, would be substantially weakened after promotion. So this was the view in Badrinath. Now, my lord will kindly come to para 24.
Yes.
Having taken note of the correct principles which need to be applied, we can safely conclude that the order of the High Court based solely on the judgment of Brisbhushan Chopra was not correct. The High Court could not have set aside the order merely on the ground that service record pertaining to the period 78 to 90 being old and stale would not be taken into consideration. As per the law laid down in aforesaid judgment, it is clear that entire service record is irrelevant for deciding as to whether government servant needs to be eased out prematurely. Of course, at the same time, subsequent record is also relevant. An immediate past record preceding the date on which decision is to be taken would be of more value qualitatively. What is to be examined is the overall performance on the basis of entire service record to come to the conclusion as to the whether the employee concerned has become deadwood and it is in public interest to retire him compulsorily. The authority must consider and examine the overall effect of the entries of the concerned officer, not an isolated entry, as it may well be in some cases that in spite of satisfactory performance, the authority may desire to compulsorily retire an employee in public interest. As in the opinion of the said authority, the post has to be made by more efficient and dynamic persons. So this is another consideration. Who is the best among the two? So he is to be retained. And if there is sufficient material on record to show that the employee rendered himself a liability to the institution, there is no occasion for the court to interfere in exercise of its limited power of judicial review. Yes. Then Milords will kindly come to para 27. At page 567. It hardly needs to be emphasized that order of compulsory retirement is neither punitive nor stigmatic. It is based on the subjective satisfaction of the employer, and very limited scope of judicial review is available in such case. Interference is permissible only on the ground of non-application of mind, mala fide, perverse or arbitrary, or if there is non-compliance with the statutory duty by the authority. Power to retire compulsorily the government servant in terms of service is absolute, provided the authority concerned forms a bona fide opinion that compulsory retirement is in public interest. So, my lord, this power is absolute. That way, it is it's not qualified. It's something like, my lord, fundamental right under Article 19 is subject to reasonable restriction. But fundamental right under Article 29 is not subject to any reasonable restriction. So therefore, my lord, some leeway is recognized in favor of the employer in the interest of the organization, or when it comes to government service, we say it is public interest. End of the day, you serve a particular organization in the public interest. Therefore, if public interest is not furthered by your engagement, then authority has power to take a call on your further continuance. Then, my lord, the last decision is 2022 5 SCC page 100.
What is the name?
My lord, CISF versus Om Prakash, Head Constable GD Om Prakash.
Huh.
Yes. My lord, I'll refer to para 12 to 15. That Badrinath's view has been taken note of here, my lord, which lordship found at para 19 of the earlier judgment. In the judgment reported as the one I read, the High Court had taken into consideration adverse entries for the period 12 years prior to premature retirement. This court held that Brijbhushan Singh was overruled only on the second proposition, that an order of compulsory retirement is required to be passed after complying with the principles of natural justice. This was actually wrong. This court also considered the washed off theory that his remarks would be wiped off on account of such record being of the remote past. A reliance was placed upon a 3-judge bench judgment of this court reported in Pyare Mohan Lal versus State of Jharkhand, and it was observed that so and so. It clearly follows from the above that clarification given by 2-judge bench in Badrinath is not correct. So para 19, which my learned friend, my lord, referred to, has been held by a larger 3 judges bench to be not correct. And the observation of this court in Gurudas Singh to the effect that adverse entries prior to promotion or crossing of efficiency bar or picking up higher rank are not wiped off and can be taken into account while considering overall performance of the employees when it comes to consideration of the case that the employee is for premature retirement. So even if you earn a promotion, the adverse entries can still be looked into. The principles of law, which is clarified and stands crystallized after judgment in Pierre Mohanlal, is that after the promotion of an employee, the adverse entries prior thereto would have no relevance and can be treated as wiped off when the case of the government employee is to be considered for further promotion. However, this washed-off theory will have no application when the case for an employee is being assessed to determine whether he is fit to be retained in service or requires to be given a compulsory retirement. So that will still be a relevant consideration. The rationale given is that since such an assessment is based on entire service record, there is no question of not taking into consideration the earlier old adverse entries or on record of the old period. We may hasten to add that while such a record can be taken into consideration, at the same time, the service record of the immediate past period will have to be given due credence and weightage. For example, as against very old adverse entries where immediate past record shows exemplary performance, ignoring such a record of recent past and acting only on the basis of the old entries to retire a government will be a clear example of arbitrary exercise of power. However, if all record pertains to integrity of a person, then that may be sufficient to justify the order of premature retirement on the government servant. In other words, my lord, when it comes to taking old then new, my lord, or the recent past, if the earlier was based on integrity, then even the later, good SAPR will also not hold good. There are numerous other judgments upholding the order of premature retirement of judicial officers interior on the ground that judicial service is not akin to other services. A person discharging judicial duties acts on behalf of the state in the charge of his sovereign function. Dispensation of justice is not only an onerous duty, but has been considered as the charge of a pious duty. Therefore, it is a very serious matter. This court in Ramamurthy Yadav versus UP held the scope of judicial review and order of compulsory retirement based on subjective satisfaction of the employer is extremely narrow and restricted. Only if it is found to be based on arbitrary or capricious ground vitiated by malafides, overlooks relevant materials, could there be limited scope of interference. The court in judicial review cannot sit in judgment over the same as an appellate authority. The principles of natural justice has no application. Thus, we find that High Court has not only misread the judgment of this court in Vaikuntanath Das, but wrongly applied the principles laid down therein. The adverse remarks can be taken into consideration as mentioned in number of judgments mentioned above. There is also a factual error in the order of the High Court that there was no adverse remarks and that the ACRs for the year 1990 till 2009 were either good or very good. In fact, the summary of ACR as reported by the High Court itself shows average satisfactory and in fact below average report as well. The entire service record is to be taken into consideration, which should include ACRs of the period prior to promotion. The order of premature retirement is required to be passed on the basis of entire service record, though recent reports would carry their own weight. So, my lord, in the ultimate analysis, what the Honorable Supreme Court has said, my lord, the principles laid down in Vaikuntanath Nath case still hold good. The scope is extremely limited. It is only when one can make out a case of no evidence, that there are no materials, then only, my lord, there could be a scope of interference. Something like, my lord, the scope of proceeding against and disciplinary inquiry. There also Supreme Court has said, unlike in the criminal cases here, unless it can be shown that it's a case of no evidence, some evidence is good enough. So therefore, my humble submission is, my lord, the emphasis laid down by my learned friend on the promotion he earned on 31/10/19 would not, come to his rescue, my lord, despite earning his promotion, as it was based on seniority. The earlier ACRs will continue to hold sway, at least in assessing whether he should be retained or not. And my lord, this judgment of the
Just, Mr. Singh,
my lord, yes,
this is a non-SSC version. Please
Yes.
tick mark those paragraphs which Mr. Chaudhary was reading.
yes.
Can I highlight the relevant paragraph?
This,
No,
not only a
paragraph
tick
is
mark,
fine.
only a tick
I
mark.
think paragraphs.
Only
We'll
paragraphs.
highlight or we'll write it.
Only paragraph, just tick mark the paragraphs.
Paragraph is fine.
I will just.
Yeah, you consult with that or SSC version and
If your lordship would kindly take this, I can't Para 15 to that.
Punjab and Haryana decision.
My lord, this gentleman, Mahabir Singh was included in that 21 along with the petitioner. Lord, 322 officers' cases were considered by the review committee, out of which 21 were compulsory retirement, including the petitioner and these petitioners. There were 6, na? No, there were 9. Please come to para 15 or page 14, my lord.
yes.
In the case in hand, petitioners were considerably promoted within the last 5 years from the date of their premature retirement. However, none of them have been promoted on merit. They were promoted on the basis of seniority cum fitness. They have been subjected to punishment on multiple occasions. In paragraph 27, I have shown, my lord, the record of the petitioner in our case. They have been subjected to multiple punishment on punishment on multiple occasions. Respondent had considered their entire service record and arrived at a conclusion that they should be prematurely retired. In view of the above cited judgment, this court cannot substitute opinion of authorities unless there is malafide or violation of fundamental right or any other statutory provisions on the part of the authorities. Petitioners have failed to point out malafide on the part of the respondent or violation of fundamental right or statutory provisions. Thus, this court does not find it appropriate to substitute opinion of authorities. The petitioners, being bereft of merit, deserves to be dismissed and accordingly dismissed. So 9 of the out of 21, my lord, approached Punjab and Haryana High Court. So this is their fate. So that is my respectful submission, my lord. And my lord, my learning.
CM has filed the affidavit because he has the power to represent that point resolution. That AG area general manager has filed the affidavit. There is a circular that he can file.
Oh, my lord, I think about a point was raised by my learned friend regarding competence of the AGM to file the affidavit. There are circular which authorize them, my lord.
If necessary, we will
Provide that circular. By tomorrow at 10:30 we give it. So, my lord, to sum up my argument, here is a case taking note of overall perspectives, ineffectiveness, integrity, appears, multiple punishments given, my lord. The authority formed the opinion that he is not fit to be retained. Therefore, since he has completed the requisite number of years of service, so therefore authority has exercised. So I don't think there is anything wrong in this exercise, my lord. So lordships will dismiss the writ petition. That's my humble submission. My lord, records my learned friend will keep. Okay. Bola. The lordship's kind permission can I take?
When you get convenient, your lordship next week on Monday or Tuesday.
No, next week will be a very difficult time.
Only so, I just want to examine those judgments of this court, which I did not in fact, so that I can try to distinguish. And I will take maximum 15 minutes. Then. It's a statement from
Do
the
it by
court.
tomorrow. Do it by tomorrow because next week, you know, the pressure of just before vacation.
Yes, sir. Huh? Huh? Okay, what will I do? Only 10-15 minutes on Monday or Tuesday, man. Any day convenient. Only 10 minutes. I will not, if it's statement from the bar, I will not take more than 10 minutes. Well, let me at least go through it, what exactly has happened. I'm sorry, this is the first time most probably I'm asking for some accommodation, but just 10, not 10, more than 10 minutes. It was actually my duty to look into these High Court judgments, which I did not.
That's okay. And Mr. P.B. Pathak, Senior Counsel, assisted by Mr. B. Chaudhary, Counsel for the petitioner. His argument is concluded, reserving right to reply. For which he pays for adjournment. Next matter, the submissions of Mr. K. N. Chaudhary, Senior Counsel, assisted by Mr. B.K. Singh, Counsel for the respondents, is concluded. Next matter is on. Make it Tuesday. It's this round. 25, 6, 2024. As a parted matter.
Hello, I will produce the record today or on Tuesday.
You can give it today because I can.
I
go
will
to it.
just have to point it out.
May I be allowed to correct that compilation? Or I will give a fresh compilation.
It is with me. I will just mark my paragraph. You will also be given.
No,
Well, then
you
end
only give that, the other one, this little
No.
market, only one,
Only that,
only that.
that was, right.
Even if you don't give it, it's okay because I have it.
No, it was actually, it all fault was mine because it should have been correct.
It's okay, you don't, need not give it because we have it. Since I have noted, you do not take it away.
Well, I will have. Though I have flag mark it, just I will have to point it out, man. Hello, this is the print from the e-file, my lord. The office is met in e-file. Down below is the e-file mentioned here, my lord. So this is the agenda note which was taken into consideration, my lord. Then next page, that is on the third page, my lord, 55. Ganesh Prasad Yadav, my lord.
Yes,
At that time, my lord, there were 129 officers were considered, my lord. As on 6/6/2023, my lord. Meeting of the review committee is scheduled to be held on 6/6/2023. So, my lord, we will come to paragraph page 11. Page is mentioned down below. Mr. The petitioner figures at 117 above. There is the remark. So, my lord, will then skip that one. Come to the biodata part. After page 17, down below.
yes,
This is the biodata of the petitioner, my lord. Next page is the career progression details.
page 17.
After 17, my lord. Complete biodata of the petitioner. Next page is the career progression details. So he was promoted to DGM, then there down below is the vigilance profile, my lord. Number 1 is the penalty imposed.
Yes.
Number 2, next page, vigilance status as on date nil. And number 3, whether he is the he is in the latest agreed list or DI, that is doubtful integrity list. It has been shown as DI list, my lord. Then the next page is the
DI means
DI means doubtful integrity. Next page is APR grading that we agreed what my senior friend has stated in the red petition, madam. Thereafter, before passing of the imping order, that minutes is there, my lord.
yes.
Minutes of the meeting of the review committee under regulation 22(2) of the FCI held on 6/6/2023 and 7/6/2023, my lord. Next page, my lord, will see the vigilance administrative profile of Sri Ganesh Prasad Yadav reflects the following position. This has been numbered 1, 2, 3, 4, 5, 6, 7, 8. That has been gathered from the personal file of the petitioner, my lord. That bunch is, we have numbered it 1, 2, 3, 4, 5, 6. That spiral binding one. Separate, my lords. So these are the vigilance remarks, man. 1, 2, 3, 4, 5, 6, 7, 8. Then at page 4, second paragraph, my lord, opinion were also collected with his present and past controlling officer and other officer in the organization who had worked with him. And the general consensus is that the officer doesn't take any responsibility, and that's why he was never assigned any sensitive independent assignments, leaving a few occasions.
You had,
Thereafter, there is the view that in view of the above, my lord, that is at page 6 down below, it is there. Page marking. Thus, in view of the above, the committee is of
yes.
unanimous opinion that the continuation of the services of Sri Ganesh Prasad Yadav, GM General, is not in the interest of the corporation and the public interest in general. Therefore, so and so deserves to be retired from the services of the Food Corporation of India. Then this imping order was passed 12/6/2023. That is at the next page, madam. Then the petitioner has filed a representation. We have flag marked the report of the representation committee, madam. That is the last one.
Yes.
So we have flag marked that one report of the representation committee, ma'am. The representation committee has gone through the petitioner representation dated 21/6/2023 and the observations made by the review committee which associated the chief vigilance officer of FCI as a co-member. The representation committee in the meeting held on 26/7/2023 has arrived at some conclusion that on 6 occasions the petitioner was given memos, SC and so cause notice charge sheets indicating various allegations or misconduct. The incumbent was charge sheeted under major penalty regulation on 2 occasions. Also, the APAR assessments prior to the year 2009 reveals that the officer had earned fair good gradings. The records indicate that the petitioner conduct and the reputation were not up to the mark. In the light of the aforesaid, the representation committee is of the observation the findings of the review committee holds good. Thereafter, the order was passed on 14/8/2023, rejecting the representation of the petitioner. So, my lord, the spiral bunding is the personal file, my lord. The observation made by the vigilance in the minutes of the meeting that has been flag marked. 1, 2, 3, 4, 5, 6, 7, 8.
What is this point number 1, 2?
Yes. Point number 1, 2 is that the complaint made by the complaint made by the staff of Satna division regarding the alleged corruption being done by Sri GP Yadav, area manager. Consequently, the officer transferred to the Maharashtra region by order dated 24/8/2009. Then 2 is regarding the officer was the charge sheeted under minor penalty dated 21/10/2010 while posted as the then area manager FCI DO Borivali for negligence towards his duties and failed to monitor the port operation efficiency and failed to keep control over subordinate staff. Penalty of censure was imposed. Then 3 is pertaining to email dated 5/5/2011 from GM Karnataka to ED South pointing towards serious irregularities committed by the officer. It has been observed his performance is not all up to the mark and there are serious allegations on his integrity. Hence, it is requested to post him out of Karnataka in view of the sensitivities of the contracts, maize procurement in this region, and based on the inputs of GM Karnataka, the officer was shifted out from the region to RO Tamil Nadu.
Okay.
Punjab and Haryana,
Okay, resume 2.
My lord, before lordship rises.
My lord may record that record has been maybe reflected in the order statement.
Yeah, the departmental Records have been produced by the learned standing counsel for the FCI.
Since in item number 13, I have concluded my argument, which is written no. But, my presence may be excused, when the Advocate General
Which one?
is supposed to
one?
reply to me.
Election matter?
Election, I have concluded.
Okay.
Only Advocate General has to. Punjab and Haryana government.
Item 10, my lord. With the apology, I am mentioning item 35, your lordship. That won't be reached today, your lordship. Would your lordship fix on 30th of September, 30th of July? I have taken concern of the other side, 30th of July, your lordship.
July is no problem.
30.
Okay.
35. Deeply obliged, your lordship.
Item 10, my learned other side is also present. Can your lordship take it up in the month of August, second week of August?
August is no issue. The only difficulty is this next week.
Yes,
No, August week.
August.
Second week.
Take a note.
Lordship
Court
will-
will take a note.
Lordship will record the presence, Lordship.
Oh, yes, ma'am.
All sides are represented on the prayer made by Mr. A. Samua, counsel for the petitioner. List on. Give a date. Just consult your diary and give a date.
14.
Yes, yes.
Much obliged.
Much
Lordship.
obliged.
How's everything? Your senior?
Is better, Lordship. Yes.
Vacation.
Yes. My lord, there is some urgency, my lord, a date may be.
Can't take it out.
This
That was the limitations.
A date may be.
Today we have got 19 mention memos for admission in on the these days. So
A date may be fixed. After
the court master will give a date after some time.
18, my lord, if 18 July, my lord, if possible.
He'll take the call. Just wait for some time. After I rise, then they'll take a call. You just give the item numbers, he will take a call.
29.
Item 29.
Item number 14 to 27. In this matter, I am appealing for the ASTC. It's a hearing matter. Lots of one affidavit we need to file. Lots of that signed copy I am going to receive today.
Item
14 to 27.
you have informed the other side.
Other side, lots of petitioners are given.
Can it be on the 19th of July?
Date, please take it out after some, because after vacation, we have there's hardly any scope because every matters are being pushed to the court master will take a call after rise, he will check the calendar and give the dates. Item number
14 to 27.
14 to 27.
All right. To mention item number 4 to 7, madam. 4 to 7. 4, 5, 6, 7.
4 to 7, yes.
But what had happened, this matter is supposed to come out in the appropriate bench, madam. The review petition is there. The wrongly has come
4
up.
to 7. Okay. 4 to 7.
That matter may come
And
up before appropriate bench.
The registration will examine and raise this matter before the appropriate bench. Yes. Being review petitions. Petition numbers 59 of 2023 and 62. Review petition 62 of 2023.
Much.
Yes.
Upgraded item 13, election petition 4.
Lordship, in this matter, learned senior counsel Mr. D. Segar was supposed to appear, but Lordship, in the break time, we found out that this matter has been fixed at 2 o'clock. But Lordship, there's another hearing matter which is going on in court 1, Lordship. Lordship,
Maybe it goes after vacation.
Lordship, immediately after vacation, Lordship.
Okay, dates will give after some time
Lord,
because
Lordship.
you're not in a position to give it right now.
Deeply obliged,
Okay, please inform Mr. KP Patel
Lordship.
or his. Huh?
He is not present today.
No, he took the permission from the court and left because it was for you to argue. So please inform his assisting counsel.
Item number 2 with 3 for admission.
Please, Your Lordship. They were supposed to file the affidavit in this matter, Lordship.
My lord. My lord, we have received instruction. Kindly allow us 2 weeks time to file our affidavit.
How much time?
2 weeks.
Or should we fix a date?
Okay, both sides are represented. The learned counsel for the transport department. Praise for is granted 2 weeks time to file affidavit in opposition to the matter. List after the ensuing vacation, summer vacation. We are not fixing a date, right? Okay.
Item 12 for hearing.
Yes. This is health matter. SC health. Yes. Yes.
Because my lord, the petitioner is a senior gynecologist in the Jorah Medical College. This is another proceeding, other two proceedings are also there. This is slightly different. Namely, following a death of a person,
Yes.
a lady, the Assam Medical Board and the Assam Medical Health Act asked prohibited him to practice and asked him to deposit the certificate before the board. In fact, my lord, there has been no enquiry at all. Rather, finding is there by the one of the members that petitioner is no way connected.
We approve it bench too. Bench hole providing Hungary আহিব.
Yes.
What happened, my lord? There is a charter of duty. According to the duty list, doctors are supposed to work. On the date of admitting the patient, the petitioner was on duty. He examined her, admitted into the hospital. Thereafter, for the necessary treatment and all that, he indicated in the bed ticket. Thereafter, defined doctors came on duty, various doctors. Thereafter, I was not at all involved. But ultimately, a doctor decided to operate her to take out the baby because baby was dead. And then the next day, the patient died.
Yes.
Before I
Lordship, actually in this matter, Mr. B. Gogoi appears, Lordship. He's in Lakes in Court 1, Lordship. There is a special bench. So today, Lordship, it will be difficult for him, Lordship. So may I pray for any other day in the next week, Lordship?
I am
Or
out of
Lordship-
job, my lord. Let me proceed, let them come and join.
No, because if it is kept parted, it will be more troubling me. Because the vacations will spill over to.
In
long
fact,
time.
on earlier date also, your lordship, on my request, your lordship fixed it.
No, it's
Anyway,
okay.
my lord, your lordship may consider that.
You choose a date, Mr. Bhattacharya. You please
25th.
choose a date of your choice.
27?
Choose a date of your choice.
25th or 27? Tuesday.
Next week, though, it will it be possible?
Next week will not be possible.
It's a motion week, then after
It's not a question of motion because there's so much of pressure on the motions and admissions.
Let it
Take-
come after.
You choose a date.
25th
Give me
of
a date.
July is a hearing date.
You choose a date of choice of
25th
Mr.
of July.
Bhattacharya.
25th of July. 25th of July is a
25th.
hearing day.
Okay.
25th of.
But next time, if you want to take time, please inform me
Yes,
in,
yes,
in advance.
But
We don't want senior counsel to wait.
Lordship,
The
today I
matter
have
is called
informed
up.
Mr.
No.
He had informed actually. He said
Okay.
before we
That's
can.
okay. Mr. A.K. Bhattacharya, Learned Senior Counsel, assisted by Mr. D.K. Bhattacharya, counsel for the petitioner is present. Mr. D. Upamanya, Learned Standing Counsel for the Health Department, praised for adjournment as Mr. B. Gogoi, Learned Counsel for the Standing Counsel for the Health Department, who is assigned with the matter, is on legs in court number 1, which is taking up a special bench. Full stop. Accordingly, matter stands adjourned today. List on 25/7. 25/7.
Deeply obliged. Lordship.
Supply item 33 for orders.
Well, we have taken stake also, my lord, but affidavit also filed, my lord.
Yes, transfer order.
Lordship.
Regarding my lord private respondent, I was asked to state lords, no?
Is service complete?
Notice issue करना है तो कुछ नहीं state level issue नहीं करना नहीं कर notice state level issue
You filed affidavit of service by email?
Yes, my lord.
Yes.
We have already filed affidavit method on 14/6/2024, my lord.
You should have got it by now. This is not tagged.
that is my lord file on 28th.
No, it's not tagged.
And on registered, my lord, on 13/6, my lord. Registered.
That has gone on 36, but email, if you have served.
The emails,
should have been got. It's not there. You take it on Monday then.
My lordship.
The
Otherwise, the matter is interim.
Yes.
Yes.
PG Mountain and Senior Counsel, assisted by Mr. I. Alam, counsel for the petitioner, submits that an affidavit of service has been filed on
14th.
14/6/2024. Just not how it is said. Affidavit is not on the contract.
Interim to Alivana.
I just said affidavit on the contract
No question.
based on Monday. 24/6/2024.
Madam, interim order pass.
Interim order passed. It stands extended till the next day.
Lordship, interim,
Oh, not on.
Interim is the notice was
Not-
for interim order, lordship. Notice issued including the interim relief prayer returnable on 18/6. It was. Sign over. Paragraph 4, lordship. 18/6,
Huh. But there's no interim order.
lordship.
Oh, but erroneously in the last order, we had extended the interim order.
No.
Oh, interim order is not there. Mr. Mahanta, interim order is not there. We,
On that day, my lord, your lordship said.
on the last occasion, we extended it, but
Coercive action has been, that was my lord pronounced. That's why I'm saying.
okay, Monday we can take it up, huh? Tuesday.
Tuesday.
Thank you. Okay, Tuesday. Okay. Monday.
If lordship please, just one line as regard the interim order on last date, lordship. That observation, lord. Interim
Okay.
order shall continue order.
It appears That
My lord, why I'm submitting on last occasion, my lord, while your lordship, my lord, declaring in that first day, my lord, your lordship, that last day, no coercive action be taken because the transfer matter, my lord. That was, I have not read the order, my lord, but it was the in presence of another council, he was not there, my lord.
That is not there, but partially transparent.
Paragraph 4, Lords.
no, you are right. But Mr. Monto says that this order was passed, but it was not typed.
Lordship.
I don't remember, in fact.
My lord, no, my lord, it was, anyway, my lord, all right, on, since it is a transfer matter, my lord.
So like, please tell them.
On next date, Lordship will take up for the matter for interim
You tell
prayer.
them not to take coercive steps. Privately, you can inform them.
No, Lordship, issue is because one inquiry is going on against the petitioner, and that is the only reason why after taking approval from the appropriate authority, transfer was issued. Because during his presence, Lordship cannot, one inquiry cannot be conducted against himself. That was the reason, Lordship, a transfer order was issued.
My lord, damn it, my lord, until next date, my lord, let them file a small affidavit on that point, next date will be hard on that, my lord. Because my lord, in a way of punishment, that cannot be done.
No, otherwise
Right,
also,
If
Lord,
inquiry is there,
My lord.
then transfer would be the best way to avoid that
Lordship, on
situation.
7th, Lordship, the transfer order was issued. On same day, Lordship, we filed an earn leave application on held ground, Lordship. Authority constituted one medical board, Lordship, issued him notice to appear before the board. He is not appearing. Since 7, he is not attending duty, nor he appeared before the medical board, Lordship.
That is after my lord. transfer, my lord.
Unauthorized.
After transfer, my lord.
From 7.
No, but still, he's referring to your conduct.
No, that is after my lord. After transfer order, I have challenged my transfer order.
Lordship, on
Your lordship-
same day, Lordship, we filed one application for earn leave. One medical board was constituted to consider his prayer
Here,
for
my
earn leave.
lord, your lordship kindly see, my lord, what is our contention? Our contention was, my lord, my transfer order was 11 years, within 11 months, my transfer order was by DC. He cannot, my lord, in fact, pass within the district, he can.
I mean, going to be married, but since interim order is not there. And
My lord.
Otherwise, Lordship, it will create difficulty, Lord. Let him join the, wherever he is there, let him come to the duty.
Okay.
On next date, Lordship will consider the interim prayer, no issue, Lordship.
Okay, prayer for interim relief shall be considered on next date. Not on Monday,
25/6.
My lord.
That
Then, my
Thursday.
lord, think that then Lord, status quo may be maintained, my lord. Otherwise, I'll be in trouble, my lord.
No,
We're not saying that. We're not saying that. Because once the order is not there.
I may be wrong, but
No,
that
you.
day I
you-
announced,
no,
my lord,
will-
I heard
I'm
it.
the last person to disbelieve you.
My lord.
I'm the last
Definitely.
person to disbelieve you. Maybe you are absolutely right. I may have made a mistake. But still, since the order
That's
is.
why next day, my lord, I pay for this. Otherwise, my lord, I would not have taken.
No, you.
My lord.
I don't doubt you.
Develop.
Item 28 for hearing.
At least, Mr. Monto, you
My
can
lord.
be assured.
My lord.
You are someone I will not never doubt. There's no representation from any side. For Angel Justice Magistrates adjourned today, list after ensuing vacation. So summer vacation.
Item 34.
Yes, the petition is agreed by declaration of unfit by review medical board with regard to selection of constable in the year 2016, my lord. Informed review medical examination report is lordship will find at page 21, my lord. Annexure 8.
But if you are suffering from 30% cubitus valgus,
Yes,
you
but
will not be fit.
that
You will
was not
be-
the main reason for declaration of unfit. Only issue was declaration of unfit was that Lordship may kindly peruse 3B. 3B, unfit on type copy, unfit page 21. Unfit on account of RT within bracket operated
perforated TM.
4 months before. Because I have to go on a eye surgery. And the duration of eye surgery was not beyond 4 months, it was within 3 months till attending the review medical board examination. That was the only reason. Except this, there was nothing else in the said report for declaration of unfit. If you lordship will, and after filing this petition, union has filed affidavit in opposition in support of their case. And we have filed rejoinder to them by denying the contentions of the union. If your lordship would peruse the affidavit in opposition of the respondents, lordship would find
Where is your opinion of the doctor which says
unfit on account of a time bound.
no, your doctor has diagnosed what?
Diagnosed some ENT problem.
No, where is that?
Lordship would find a page 17, my lord.
17.
17 in the read petition. It is the discharge certificate. Type copy is page 16. 16.
Mr. Paul, you'll still not be entitled to the for a reconsideration against the
I have a
medical
case, my
opinion.
lord, in lordship may kindly come to para 10 of the read petition.
Para 10.
10 and 11. Entire story is summarized there in this read petition. My case. And lordship will be able to appreciate the entire case. Because I have been declared merely on the basis of some time duration of attending, and the date was fixed by the respondent. It is not in my hand to fix that site date. I have attended after surgery. If I would attend the site board after 4 months, then might have been declared fit. But as per their call, I have attended on that date of 10/9/16. That is the limited issue involved in this case. Only date of attendance. Except that there is nothing. That's why we have summarized our case in paragraph 10 and 11. And so far as if your lordship will kindly consider their objection at page, your lordship may kindly go through paragraph 10 and 11. If something clarification required, I will then submit.
But you see your, this medical standard at page 24, it says existing perforation
Yes.
or history of surgery to correct preceding 120 days. So if it is 120 days, naturally you will be rejected.
If they would call me after 4 months, then I would definitely attend before the board on after 4 months, as they have called, or it was not proper for the respondents to declare the said result. If
No,
there was
they-
something
no, no.
error or something
This
deficiency of
medical
my
test-
part, then they have to declare the said result after 4 months. But that
No, where
has
is
not been
that?
done.
Where is that?
Yes,
Therefore,
input, as I have submitted before your lordship, input page 16, sorry, page 21 to 26
of your
read petition.
writ petition.
Unfit only, paragraph 3, type copy. Paragraph 3B, unfit on account of comrade RT operated before 4 months. That is the only reason. And the doctor who has the board which has disclosed this one has not been endorsed by the said doctor who has conducted my test, Dr. Kuhelika Goho. Post report is
No. Is it your case that your medical was done out of turn?
not out of turn, man.
Then
I have to undergo surgery in the Nightingale Hospital.
no, that's okay. It's not in dispute.
Yeah.
But the question is that once there is a thumb rule at page 24 that
Page
once you have an existing tympanic membrane perforation
Yes,
preceding 120 days,
yes.
then you can't. And where is the review medical board?
Review medical board was held on 10/9/16, which your lordship will find at page 21. Report is there, type copy.
What is the date of your operation?
Date of operation was 8/6/16.
8/6/16,
which I have submitted at page 16.
medical board, first medical board was on which date?
No, it was the first medical board. There was no any medical board further.
No,
First of all,
once it is review medical, that
yes,
means.
review medical.
that
First
means-
medical was right. I have passed written as well as my physical efficiency test. Thereafter, once if as per their rules, force rules, if someone declares unfit by the board.
So that means
then, he have to
medical
attend before the
medical
review
board was there. What is the date of first medical?
First medical, lordship will find that Annexa 2.
Give me the date.
Yes, 14, page 14 or 15 might be looked into.
Give me the date.
Two 6/16.
2/6/16.
2016. Here in type copy, lordship will clearly find medical examination of candidates for combined entrance recruitment of constable GD in Central Armed Police Forces, review medical examination of unfit candidate. Mr. Sulemanuddin Mia, roll number so and so, is hereby informed that he has been medically examined for recruitment so and so on 2/6/16 at Silchar and found him unfit due to reasons mentioned below. And the reasons where your lordship will find perforated tympanic membrane RTR and cubitus valgus before 30 carrying angle over RT 32 LT to 35. If your lordship will go to affidavit in opposition at page 20, the scenario will be clear. Affidavit in opposition, page 20. 7G. Rule 7G. here in this, it is specifically mentioned the healed tympanic membrane is a minor acceptable defects and it can be cured. Acceptance of candidates suffering from tiefling defects, candidates presenting with mild degree of the following defects may be accepted as specified in the relevant paragraphs. So and so, these are the diseases. And my case is covered under by 7G, healed tympanic membrane perforation. Only that was, I was not declared unfit only for any defect. I was declared only some very practical manner by considering that that I have appeared before 4 months before the review medical board. Except this, there is nothing on merit. A time duration is under challenge.
Yes, which page?
Page 20, man.
Hmm?
20 of affidavit in opposition. 20.
Yes.
Ashima kindly looked into clause number 7, minor acceptable defects.
Yes.
In paragraph G is covered by this case. Healed tympanic membrane perforation. It was some healing in right up during the time of selection process. And it is not a, cannot be treated to a major defect. So far as any defect, I have not been unfit declared for any defect. I have been declared unfit by considering a time limit, and which has been fixed by the respondents, not by myself. That is the limited challenge in this repetition matter.
Okay. Yes, what do you have to say?
Everything is done on the basis of the OM, page number 24, Lordship, of our affidavit in opposition. Okay. Here it is.
Why did you not do after 120 days? So Paul is asking that. You could have postponed it for some days. when you do a review medical, you are required to go before the doctor and tell him that you have been diagnosed of this in the army selection. And there's a requirement in the form.
Yes, I have
That-
maintained all these formalities. After completion of all formalities, that's why my payer was allowed.
No,
There is no dispute to that effect, what your lordship is making query. And,
no, in this medical certificate, you are showing at page 17
which page, my lord? Page 17, my petition.
or any other document, there's no mention there that
Yes, with regard to their formality, in regard to each and every candidate, if someone is declared unfit at preliminary
no,
stage.
there is a requirement
Yes,
of the form that when you go to for review, you go to a doctor.
yes,
You have
yes,
to tell him that earlier there is a certificate
yes.
and the doctor giving a certificate shall refer to it
Yes,
in the
everything has
form.
been done. There is no dispute with regard to.
No, but
all
why
these things.
why have you not produced that?
I have done everything, my lord. With
No,
regard to that,
why?
respondents have not disputed these issues. And fact in issue in this case only regarding a time limit of attending the review medical board, except that there is nothing challenged before this honorable court. Whatever your lordship query is correct, but that has been already been done in letter and spirit. And officials, respondents have no issues with regard to that adherence on my part. Everything formalities have been done, and after completion of all formalities, this situation arose.
Okay. What is your name?
KK Medi.
KK Medhi.
I am appearing on behalf of Mr. SK Medi CGC.
Okay, I'll deliver orders in chambers.
Obliged.
It will be uploaded only tomorrow. I am leaving right now. Leaving the court now. Chamber. It will sleep.